Judgment in the matter of the Corporation of Hamilton against the Attorney General of Bermuda and another.
Lady Rose will hand down the judgment.
The Corporation of Hamilton administers the city of Hamilton, which is the capital of Bermuda. The corporation is a corporate body with a long and complex history. In recent years, the relationship between the corporation and the central government of Bermuda has been turbulent. However, this appeal does not concern the reasons for their disagreements, and the board has not formed any view on them. Instead, the board has been asked to consider the proper interpretation of the Bermudian Constitution and how it applies to the facts of the case, which are largely undisputed. The corporation relies on Chapter 1 of the Constitution to challenge the compatibility of certain provisions of the Municipalities Act 1923 with the fundamental human rights conferred by that chapter. The 1923 Act has been amended by successive Municipalities Amendment Acts over many years. In 2015, a new section, numbered Section 7AA, was inserted into the 1923 Act. Section 7AA confers a power on a government minister to give directions to the corporation if he considers it to be in the best interests of Bermuda for him to do so. The section then imposes a corresponding obligation on the corporation to comply with those directions. A further amendment to Section 7AA, introduced in 2018, provides that anything done by the corporation when it complies with such a ministerial direction is deemed to have been done for a municipal purpose of the corporation. The challenge brought by the corporation does not just complain about existing provisions of the 1923 Act. In 2019, there was a reform bill which was debated by the Bermudian legislature, in which further amendments were proposed. If the bill had been passed, it would have had the effect of transferring control away from the current elected members of the corporation to ministers in central government. The bill would have abolished all future elections for the corporation's members so that the new people in control of Hamilton would be appointed by government ministers. Although the bill was rejected by the Senate, the minister has indicated publicly that it is the government's intention to table the bill again. It is still useful, therefore, for the board to consider the terms of the bill in case something like it is introduced into the House of Assembly in the future. The corporation did not succeed in its challenge in the courts below. The Chief Justice dismissed the corporation's claim in his judgment of 31st March 2021. The Court of Appeal dismissed the corporation's appeal on 18th of March 2022. The corporation now appeals to His Majesty in Council. In a judgment of the board, the Judicial Committee advises His Majesty the King to dismiss the corporation's appeal. The first issue arising is that the corporation asserts that these recent and proposed amendments to the 1923 Act amount to an expropriation of the corporation's property without compensation. This is contrary, they say, to Sections 1 and 13 of the Constitution. This raises the question whether Section 1 of the Constitution confers freestanding rights or is only an introductory section. The importance of this is that Section 1C seems to be broader than Section 13. Section 1C says that everyone in Bermuda has the right to freedom from deprivation of property without compensation. But Section 13, which elaborates on the scope of this right, says that no property shall be compulsorily taken possession of or acquired without compensation. The corporation argues that the wording of Section 1C, by protecting it against deprivation of property, confers a broader right than the wording of Section 13, referring to property being compulsorily taken possession of or compulsorily acquired. And they say they can rely on the wider wording in Section 1C, even if what has happened does not fall within the narrower wording of Section 13. In the judgment, the board reviews many earlier cases from the Bermuda courts and from the board on appeal from other jurisdictions some of whose constitutions have introductory sections in similar terms to Section 1. The Board concludes that Section 1 is not separately and independently enforceable. There are aspects of the wording of Section 1, for example, that it starts with the word whereas, that indicate that Section 1 is in the nature of a preamble or recital and not separately enforceable. Further, to construe Section 1 as having independent force would give rise to difficulties. Section 13 and other more detailed sections in Chapter 1 contain important limitations, qualifications and exceptions to the rights they confer. So it would not be clear whether and how those would apply if Section 1 does not expressly contain those same limitations conferred by the rights themselves. The Board later in the judgment considers whether what has happened or what would happen if the proposed 2019 Reform Bill or something like it was passed in future, whether what has happened amounts to a breach of Section 13. If the government replaces the current elected members of the corporation with its own appointees, has it compulsorily taken possession of the corporation's property? The Board concludes that it has not. The earlier cases relied on by the corporation do not establish that a change in the management and control of an enterprise in these circumstances can amount to a taking of property or the taking of an interest in property. The corporation continues to own its land and property, and it also continues to have day-to-day control over that land and property. The Board accepts that the taking of property does not have to involve a transfer or change of ownership or possession from one person to another, but the measure being challenged has to be a really serious interference with the owner's rights before it can amount to a taking for the purposes of Section 13(1). The replacement of the elected members with government appointees and the minister's powers to direct the corporation in the legislation which the corporation challenges do not, the Board concludes, meet that threshold of seriousness and do not therefore amount to a taking within the meaning of Section 13(1). The second issue arising is where the Board considers whether the right conferred by Section 1A of the Constitution to the protection of the law may be independently enforceable even if in general Section 1 is not. The corporation contends that the amendments in Section 7AA are contrary to the right to the protection of the law. This is because the effect of them appears to prevent anyone challenging any action taken by the corporation as being out with its statutory powers. If the statute now deems everything the corporation does to be within its powers, provided only that the minister has told it to do that, then in effect, a minister can extend the powers of the corporation to cover anything at all, even if it appears to be completely outside the functions that the legislature conferred on the corporation by the 1923 Act. Again, the Board looks at the earlier case law on similar provisions elsewhere in the Caribbean and considers that the protection of the law referred to in Section 1A may be independently enforceable, even though Section 1 in general is not. However, at the hearing before the Board, the Attorney General of Bermuda fully accepted that despite its current wording and despite how it would have been amended by the 2019 Reform Bill, the actions of the corporation would be subject to the normal constraints imposed by the law on a statutory body with limited powers. In other words, the government accepts that Section 7AA does not mean what it seems to say. In the light of that, the Board concludes that there is no need to determine that issue now. It can be considered if and when there is a challenge to some action by the corporation in future. The third issue addressed was raised with the parties by the Board itself prior to the hearing. That issue is whether the corporation is the kind of body which enjoys rights conferred by the Constitution at all. The judgment notes the lack of relevant case law on this issue, and the Board explains its doubts as to whether the corporation is the kind of person which does enjoy constitutional rights of its own. But since the Board has come to clear conclusions on the other issues in the appeal, it does not express a concluded view on the corporation's standing. Finally, the Board rejects the corporation's submission that the 2019 Reform Bill would have stifled the opportunity for political expression by the current electors of Hamilton, contrary to Section 9 of the Constitution. Section 9 is the section that confers a right to freedom of expression. The Board concludes that it's very doubtful whether there is a constitutional right to vote in elections in relation to municipal authorities rather than in general elections to the country's legislative bodies. Even if there were such a right, that does not prevent the legislature from abolishing elections or voting rights for municipal bodies that the legislature has itself created. The Board rejects the distinction that the corporation sought to draw between the right to vote for a forum that currently exists and the failure to create a forum. Having examined carefully all the points that the corporation argued, the Board has concluded that there is no current breach of the corporation's rights under the Constitution.
Thank you. Court is now adjourned.